On behalf of the School of Government and Social Sciences, I would like to extend a warm welcome to all of you attending today's conference on a critical issue within the Mexican criminal justice system, pretrial detention. We are honored to have such a diverse audience today, with participants from various sectors, including academia, law, civil society, and public policy. Your presence here reflects a shared commitment to understanding and improving one of the most challenging aspects of our justice system. Pretrial detention, as many of you may already know, remains a complex and controversial issue. It affects not only the rights of the accused, but also the overall efficiency and fairness of the legal system. In recent years, Mexico has indeed undertaken several reforms and overhauls aimed at strengthening the process and reducing the overuse of pretrial detention. Yet, many challenges persist, especially when it comes to balancing public security with individual rights. Today, our distinguished panel of experts and myself will provide insights into the definition of pretrial detention, the current legal and constitutional framework, the types of pretrial detention, the rules of proceedings, important jurisprudence criterion, and the recent Inter-American Court ruling pertaining to the case of Garcia Rodriguez and others versus Mexico. We encourage you to participate and engage in the discussion actively. Without further ado, thank you all once again for joining us. In the simplest terms, pretrial detention consists of the incarceration of a person during a criminal proceeding prior to sentencing. In the Mexican criminal justice system, its legal nature is regarded as one of a precautionary measure, as it removes the right to liberty from a legally innocent person who has not been convicted of any crime on the basis of evidence that has not yet been fully examined. Additionally, the first chamber of the Supreme Court of Justice of the nation, Mexico's Federal High Court, on the jurisprudence thesis 35/2012 with digital registration 2000631, has stated that pretrial detention comprises the effective time in which the person subject to criminal proceedings remains deprived of their liberty, from their detention until the first instance judgment causes state, or the second instance judgment is issued that definitively resolves the situation, without having to add to that period the time in which the amparo trial, if applicable, is resolved. Nevertheless, if as a result of the amparo trial, constitutional protection is granted to annul the judgment and reinstate the procedure, then the time during which the person is deprived of their freedom to carry out the actions corresponding to the phase of the reinstatement process and until a new final and firm judgment is issued must then also be considered within the time of pretrial detention. Pretrial detention is a figure contemplated in Article 19, second paragraph of the Political Constitution of the United Mexican States. Something of note is that Article 20, Chapter B, Section 9 of the same instrument establishes that pretrial detention cannot exceed the time established by law as the maximum punishment for the crime in question, but in no case shall it exceed the term of 2 years, unless the defendant asks for an extension to prepare their defense. This constitutional provision goes on to stipulate that if after said term a judgment hasn't been issued, the defendant shall be released immediately without prejudice to the continuation of their trial. Furthermore, Article 155, Section 14 of the National Criminal Procedure Code provides pretrial detention as part of the vast catalog of precautionary measures that may be imposed on the defendant by the supervisory judge at the request of the public prosecutor's office or the victim or the injured party. Still, pursuant to Article 154 of this code, any precautionary measure shall proceed when the accusation has been made and the defendant has availed himself to the constitutional term of 72 or 144 hours, and the defendant is bound over to trial. In the same line of argument, Article 165 of the Criminal Code in question declares that pretrial detention will only be mandated for a crime punishable by deprivation of liberty. It goes on to explain the exact same thing that the aforementioned Article 20, Chapter B, Section 9 of the Mexican Constitution provides regarding its maximum duration and exceptions due to the exercise of the accused's right of defense. Taking into account what I've discussed so far, it's only appropriate to differentiate between the two types of pretrial detention contemplated in the Mexican criminal justice system. Firstly, the justified. In terms of Article 167 of the discussed Criminal Procedure Code, per request of the public prosecutor's office to the supervisory judge, pretrial detention shall only be mandated when the rest of the precautionary measures prove insufficient to guarantee the defendant's appearance at trial, the development of the investigation, the protection of the victim, the witnesses, or the community, in addition to the defendant being subject to the criminal proceedings or who has been previously condemned for the commission of an intentional crime. On the other hand, we have the mandatory, also known as automatic pretrial detention. With respect to pretrial detention of this nature, its normative foundation is established in Article 19 of the Mexican Constitution, specifically in the second sentence of the second paragraph. The character of this type of detention is inherently automatic, which means that it doesn't require any legal justification whatsoever. This process occurs without the necessity of the additional stages of the criminal procedure, requiring solely of the indictment of the individual for any of the offenses delineated in Article 19 of the Constitution. Some of these offenses that warrant mandatory pretrial detention are as follows: sexual abuse, violence against minors, organized crime, intentional homicide, rape, kidnapping, residential burglary, crimes committed with violent means such as explosives or weapons, as well as serious crimes that determine the law against the security of the nation, the free development of personality and health. Regarding the provisions of Article 20 of the Constitution, which establishes the maximum duration of pretrial detention, the authorities adjudicating these appeals have interpreted the provisions of Article 19 on mandatory pretrial detention as an exception to the text in Article 20. Consequently, under this interpretation, for the offenses enlisted in Article 19, there is no possibility of being released after 2 years as stipulated in Article 20, nor is there a requirement for periodic review of the precautionary measure. In the context of mandatory pretrial detention, it is sufficient for an individual to be charged with a crime for the measure to apply, persisting until a sentence is rendered. This approach precludes the ability to assess in each case whether the precautionary measure is appropriate, necessary, or even proportionate. Under these circumstances, the principle of the presumption of innocence is rendered ineffective. The discussion surrounding this measure has primarily focused on its implications for the human rights of citizens. One of the gravest consequences of mandatory pretrial detention is that numerous Mexicans may spend over a decade deprived of their liberty while waiting trial, without a formal sentence and under conditions that present significant risks to their lives and, most importantly, their personal integrity. Furthermore, this practice exacerbates prison overcrowding. Notwithstanding the aforementioned concerns, the Mexican government has actually publicly defended mandatory pretrial detention and has requested to the Supreme Court to uphold the constitutionality of this restriction.
Now, the discussion regarding the need to impose pretrial detention or any precautionary measure for that matter can be found as part of the proceedings of the initial hearing. Indeed, Article 157 of the National Criminal Procedure Code states that all requests pertaining to the imposition of precautionary measures shall be resolved before the supervisory judge during the hearing and in presence of the parties. Moreover, pursuant to Article 158 of the aforementioned Code, once the indictment has been made or if the case the defendant has been bound over to trial per the public prosecutor's office request, the victim or the injured party, the supervisory judge will allow for the debate on the need to impose or modify precautionary measures. Nevertheless, only the public prosecutor's office is authorized to request pretrial detention, which cannot be combined with other measures foreseen in the Code, except for the precautionary embargo or the freezing of accounts and other securities pertaining to the financial system. This stems from the principle contained in Article 156 of the Code that declares that the imposition of one or multiple precautionary measures must consider the arguments offered by the parties or the explanation given by the public prosecutor's office, while simultaneously applying the minimal intervention criterion in relation to the defendant's particular circumstances and the text found in Article 19 of the Mexican Constitution. Consequently, the measure must be ideal and proportionate, taking into account a risk measurement analysis carried out by experts in an objective, impartial, and neutral manner. Naturally, the supervisory judge, in the resolution, must enlist the reasons why the imposed measure is less damaging for the indicted. Lastly, it is imperative to note that, in terms of Article 159 of the Code, any resolution pertaining to a precautionary measure must contain the imposition of said measure and the grounds on which it is imposed, the guidelines for its application and its duration. Nonetheless, all judicial decisions on this subject are appealable. It's only fair to remember that according to Article 171 of the Code, the parties may summon data or offer evidence with the aim of requesting the imposition, revision, substitution, modification, or ceasing of pretrial detention. In addition, it is important to approach the following binding legal judgment decisions that help us to understand the criteria that must be applied in particular pretrial detention cases. The Collegiate Circuit Court for Criminal and Administrative Matters of the 22nd Circuit on the jurisprudence thesis with digital registration 20-28-13-0 solved an amparo of review that was presented against the imposition of mandatory pretrial detention. In this case, the magistrate conceded the constitutional protection under the following arguments. The Collegiate Circuit Court determined that for the application of the constitutional restriction to the personal liberty contained in Article 19, second paragraph of the Mexican Constitution, the supervisory judge must, before considering the pretrial detention, resolve whether the imposition of this precautionary measure is necessary, proportional, and suitable to comply with the purposes of the criminal proceedings. On the other hand, it refers that the constituent power must reform the federal constitution according to the international judgment of the Inter-American Court of Human Rights in the case of Garcia Rodriguez versus Mexico. The criteria that must need to be taken into account and to follow is to analyze favoring the individual in accordance with the pro persona principle.
On the other hand, the Collegiate Circuit Court in criminal matters of the Ninth Circuit on the jurisprudence thesis 9.p.J-5 between parentheses 11a with digital registration 2027-76-6, the amparo judge rejected the application of the proportionality test mandated by the Inter-American Court of Human Rights in the case of Garcia Rodriguez et al. Versus Mexico due to the thesis contradiction 200-2011 from the plenary session of the Supreme Court of Justice of the nation that there was a restriction of the constitutional range that was above from the American Convention on Human Rights. Nevertheless, the thesis states that the Article 19, second paragraph of the Federal Constitution must be interpreted with the pro persona principle and apply the proportionality test, along with the parts may debate, offer proofs, and subsequently the judge must exercise its discretion to make a well-founded and reasoned decision on the corresponding determination. Last but not least, the case of Garcia Rodriguez et al. Versus Mexico solved by the Inter-American Court of Human Rights, in which they determined that the human rights of Daniel Garcia Rodriguez and Reyes Alpizar Ortiz were violated by the Mexican state and determined that the arraigo and mandatory pretrial detention were unconventional and unconstitutional as they were applied in wrong cases that violated the right to liberty of the people aforementioned that were wrongly imprisoned. The differentiated treatment evident in this context manifests in the fact that individuals accused of certain crimes are deprived of the opportunity to exercise control over their situation or to adequately defend themselves against such measures, given the constitutional mandate that imposes deprivation of liberty. Daniel Garcia Rodriguez and Reyes Alpizar Ortiz were imprisoned for 17 years and under pretrial detention, of which also they argued that during that extended time, they suffered severe mistreatment during the arraigo period. It is pertinent to note that Article 8.2 of the American Convention stipulates that every individual is entitled, on an equal basis, to various minimum guarantees of due process during legal proceedings. The Inter-American Court has determined that the automatic application of mandatory pretrial detention, without consideration of the specific circumstances of each case and the legitimate purpose for restricting an individual's liberty, constitutes a breach on the right to equality before the law, in violation of Article 24 of the American Convention, and undermines the guarantees of due process as outlined in Article 8.2 of said instrument. With respect to the limit on the time a person can remain in mandatory pretrial detention, the Court has reiterated that this measure must be subject to periodic review, ensuring that it does not extend beyond the justified duration of its imposition. It is essential to assess whether the purposes, necessity, and proportionality of the measure continue to be met and whether the length of deprivation of liberty exceeds the limits established by law. The judicial authority is not required to wait until the issuance of an acquittal to grant liberty to a detained individual. Instead, it must evaluate these factors continuously. In this sense, the prolongation of pretrial detention for an extended duration can effectively subject defendants to a covered punishment without conviction, constituting a punitive measure devoid of a prior trial and lacking proper guarantees. Such circumstances can lead to an unreasonable duration of detention, which may equal, if not exceed, the length of a typical sentence. The Human Rights Committee has emphasized that this regime must not be employed to circumvent the limits and guarantees of the criminal justice process or to impose a sentence without trial. Consequently, any determination that pretrial detention no longer satisfies these conditions must result in the ordering of the individual's release without prejudice to the continuation of the respective legal proceedings, thereby upholding the principle of the presumption of innocence as enshrined in Article 8.2 of the American Convention. The Court concluded that the state had violated the right not to be unlawfully deprived of liberty contained in Article 7.2 of the American Convention to the detriment of the victims, the right to be informed about the reasons for detention, Article 7.4, the right to be brought promptly before a judge or other officer authorized by law to exercise judicial power, Article 7.5 of the American Convention, and the right to the presumption of innocence.
As we come to the close of today's conference, I want to take a moment to sincerely thank each of you for your participation and engagement throughout the day. Before we conclude, I'd also like to extend a special thank you to our speakers of today for sharing their expertise and to the organizing team for making this event possible. And of course, to all of you, the participants, for your contributions. Thanks again and have a great day.